Forum. For those of you who don't know, this U Immigration Forum is a nonprofit that's dedicated to the progress and full inclusion of immigrants in all aspects of our community. We do several different things, from celebrate the diversity and culture that immigrants contribute to our community, educate the public about issues affecting local immigrant communities, advocating on behalf of the rights of immigrants and encourage their full participation in civic, cultural, social, and political life in our community, and then organize for policies and practices that lead to the just and humane treatment of all immigrants that are part of our community. Each month we meet here at the University Y on the second Tuesday at 5 o'clock. Originally we'd get together and just have sort of informal conversations. The last several months we've begun having a specific topic for focus for conversation and presentation by some speakers. So tonight we'll be looking at the issue of wage theft and some of the labor issues facing immigrant workers in particular. We have a couple of very informed speakers who will give some opening remarks, and then we'll just open some conversation to everyone who's here. I also want to make a couple of announcements before I introduce the speakers. First of all, the CU Immigration Forum is having their third annual immigrant welcoming ceremony. We give awards every year to individuals and institutions for their work in making immigrants feel welcome into Champaign-Urbana. That's going to be on Saturday, September 24th, so a couple of weeks away. It's going to be at the Urbana Free Library in Urbana, of course. There's a workshop at 1 o'clock, and the award ceremony will follow at 2:30 in the afternoon, again on Saturday, September 24th. There's some flyers over there. I welcome you to join us on the 24th. The second thing is there is a sign-in sheet over there, so if you would like to be on our mailing list and get information about the work that the CU Immigration Forum is doing, please sign in, and we'll add you, and you'll get updates and information about what's going on in our community around issues affecting immigrants. So for tonight, we have two speakers who will be joining us. The first is a wage and hour investigator with the U.S. Department of Labor, Todd Swansina. Sorry. Todd is a well-seasoned investigator with experience in all of the acts that we compel compliance, and especially the Full Labor Standards Act of 1938. He has worked cases involving H-visa immigrant workers in hospitality and agriculture. He has spent numerous hours reconstructing hours worked and conducting interviews to ensure wage earners receive their just due. Todd has a plethora of knowledge in the area of tipped employees and examples of exempt and non-exempt salary workers. So we're going to hear from Todd first, talk a little bit about federal policy and rules and regulations that are going to be impacting overarching the immigrant workers in our community and all workers. And then the second speaker will be Sean Morales-Doyle. Sean is a labor attorney, and he's represented workers and unions in a wide variety of cases, including employment discrimination, wage and hour, and employee misclassification, ERISA, National Labor Relations Act, labor management relation matters. He's also litigated a number of constitutional and civil rights matters, including cases involving free speech, voting rights, gerrymandering, political misconduct, race discrimination, and sexual assault, and the Only Civil Rights Act. Finally, Sean serves on the legal advisory board of Arise Chicago, which is a nonprofit that builds partnerships between faith communities and workers to fight workplace injustice through education, organizing, and advocacy for public policy. So first I'm going to ask Todd to come up and talk for a few minutes, and then we'll have Sean come up after that. Todd.
Hello, everyone. As I said, my name is Todd Swansina. I work with the U.S. Department of Labor Wage Hour Division, and I'm a labor investigator. What that basically means is my job is to ensure that employers out there who employ everybody who's an eligible worker, they employ them properly within the constraints of the law. So some of the laws that my agency enforces are specifically oriented towards immigrants, but the majority of them are really for everyone. So the most popular law that keeps my agency the most busy is the Fair Labor Standards Act. Everybody probably is familiar with that. That's the law that sets minimum wage, overtime, record keeping, and child labor requirements. So what usually happens with our agency is an investigation can happen for a couple of different reasons. The first could be someone filed a complaint. We have a complaint line, and there are some materials over there. This is for everyone too. If you all have an issue with an employer, please pick up how to file a complaint. You can call the number and someone will help. So sets minimum wage overtime record keeping child labor requirements. So I go in, we get either a complaint or a case file that says go there and do this, and then I go out and do that. I either announce my presence or I can walk into, either way. That I don't need any kind of a search warrant, or I don't generally need a subpoena. It's already authorized by law that I go into a place of business and conduct an investigation. Now, how that touches immigrants is, within our agency, we have probably a handful of challenges that come along with just doing a regular investigation. When you have immigrants or even any kind of foreign worker, you have, first of all, the most significant language barrier. I mean, it's always the most difficult. There's a handful of us at the agency that speak different languages. We have a translator service that we can get on our government phone and do an interview with an employee. That's always a hurdle, but we can negotiate that. The second challenge is there's a bunch of different cultural issues that you have to understand as an investigator when you go in and you try to interview someone to make a determination if the employer is paying in compliance. Because there's Latin culture, and there's Chinese culture, and there's Islamic culture, and so within those different cultures, there's layers and different concepts that as you do this job for longer and longer, you get more and more aware of it. Many times we experience employees that are foreign workers that feel compelled to protect their employer. They feel like they make us out to be a bad guy. We do everything we can do to try to relieve them that we are not there. And we are not, Wage and Hour Division is definitely not INS. So we don't deport people, we don't do anything like that. Now, another law that we do enforce is visas, but the visa situation is only the requirements based upon what an employer has to do to bring a foreign worker over. So if a foreign worker is here illegally, our focus is not on the foreign worker. Our focus is on the employer who brought them over, and what did you fall apart in the process to have this worker here illegally? So that's our situation. We also enforce other laws like the Family Medical Leave Act, the Migrant Seasonal Protection Act, the Polygraph Act, which is probably our least investigated. We probably get one complaint a year on that. Somebody gave me a lie detector. But that's basically what we do. We try to make sure that when we go out, that everyone is paid at least federal minimum wage, that everyone is getting paid for all the hours that they work, and everyone gets paid for working more than 40 in a work week if they're a covered employer. Now, I will say that a covered employer in a lot of these situations is the kicker in a lot of what Federal Wage and Hour Division does. Because in order for the Fair Labor Standards Act to apply to a business, the business has to gross at least $500,000 a year. It has to be engaged in interstate commerce or whatever it is. Okay, so if there's a mom and pop diner and they're only grossing $250,000, there's a huge possibility that Wage and Hour can even touch them. Unless the employees themselves engage in interstate commerce, and there's different ways that can happen. If you're a server, you run a credit card, you create an interstate transaction, you can do that. If you answer long distance phone calls or open mail, those kinds of things, we can get coverage and apply minimum wage and overtime in that work week when it happened only. That's called individual coverage. Enterprise coverage, again, the employer has 500,000 or has a gross volume of $500,000 a year. And what that means is that everybody in the establishment for the full investigative period is covered under the Act. Okay? And the statute of the Act is always 2 years. So Wage and Hour Division, once we've established coverage, we can only go back from the day we enter 2 years back from that day. So if it was, fortunately, if your wages were being garnished for the last 10 years, you can only go back 2 years. Now you all know that federal minimum wage is $7.25 an hour. State minimum wage is $8.25 an hour. So there's a little bit different disparity there in those two wages. And there are times when the state can get an employee more money than the federal government because of that disparity. So, and we see an issue with that mostly in the Midwest. There's a lot of states in the Midwest that have higher minimum wages than federal. And we have some of the folks who just fare better by filing a complaint with the state. However, I will tell you that usually the federal wage and hour division is faster at investigating a complaint. We can usually get to them quicker and get them done quicker and get people paid quicker than the state of Illinois. I don't want to speak for the whole country, just my experience. So, that being said, does anybody have any questions?
And if it's all right, we'll bring it back up for the conversation later.
Sure, absolutely. Okay,
Thank you, Todd. Sean, do you want to come up here?
Hello everybody, my name is Sean Morales-Doyle, and I am an employment attorney. First and foremost, I do some civil rights and constitutional litigation as well, and as a result of doing both of those things, we often work with immigrant workers and on issues affecting immigrants specifically, but also like Todd, I work on things that impact people across the board. And while occasionally immigrant-specific issues will come up in a case, a lot of times the fact that a client of mine is an immigrant is really sort of a secondary consideration that has nothing to do with what we're working on. But these are issues that I find, I work up in Chicago, very, very prominent issues in the immigrant community because unfortunately a large percentage of people in low-wage jobs where people are being exploited, employers who feel like they can take advantage of their workers, a lot of that happens in the immigrant communities. And I think that based on what little I know about what's going on down here, that is the issues that impact immigrant workers in downstate Illinois are changing, in part because the immigrant population in downstate Illinois is changing. I grew up down here, and I think that the transition from more migrant and agricultural work to people working in every type of job you can imagine has been a change that's happened over the course of my life. And so the issues down here may look more like what they are up in Chicago now than they used to. The fact is that the laws that govern agricultural workers are different than laws that govern people who work inside. And there are also different ways that employers try to take advantage of workers depending on the type of work that they're doing. A couple issues that I want to raise that I won't spend too much time just going back over the stuff that Todd already talked about with regard to the federal minimum wage and the protections that the Fair Labor Standards Act, FLSA, provide workers. I think there are a couple issues that I see time and time again outside of FLSA and sometimes in the FLSA context that are, I'd say, rampant problems that employers are engaging in this type of behavior all the time in all kinds of industries, immigrant workers, non-immigrant workers. But I think the way that it impacts immigrant workers is twofold. One, that employers often feel that they can take advantage of immigrant workers either because they don't think that they'll know their rights or because they think they're not going to be willing to stick up for themselves because they have fear about coming into contact with different institutions and lawyers and things like that. Or that they're just worried about losing their job, which is a big concern. And the second reason they think they can take advantage of people is because or the second reason why it impacts immigrant workers is that people who don't have work authorization are sometimes more likely to end up in situations where their employer is not acknowledging them as an employee. And so that's the first issue that I'd like to raise, which is misclassification of employees. People who work for their employer and are not called employees by their employer. This is something that happens all the time. You'll hear people talk about it in different terms. They'll say that someone's an independent contractor. They'll say they're a 1099 employee instead of a W-2 employee because they get a 1099 And that's a really big problem for a number of reasons. One reason is your taxes, but another reason is that employers use this as a way to try to shield themselves from liability, from being responsible for following employment laws. So if I don't consider you my employer, then maybe I don't have to make sure you run the minimum wage. Maybe I don't pay you overtime. Maybe I don't pay workers' comp insurance, unemployment insurance. I don't recognize that there's anti-discrimination laws that apply to my relationship with you. Employers do this all the time in all industries, but I'd say a couple that are very common are any type of work where you're driving and restaurant work a lot of the time. So those are both industries where there's a lot of immigrants working. And it adds an extra hurdle sometimes to litigation, because to file a lawsuit is standing up for yourself, because the first thing you have to do is prove that you're actually an employee, and then you have to prove that they violated your rights as an employee. But really, a lot of times there's not a lot that goes into, these aren't very sophisticated attempts by employers, right? Employers just basically say, you're not my employee and I'm not going to pay you like my employee. And sometimes employers think that this is something that their employees would prefer if they are immigrants, because if they don't have work authorization, maybe they don't want to be considered an employee. But the thing to remember is that whatever your employer calls you is irrelevant. It just doesn't matter. It doesn't matter whether they call you an employee or not. The law doesn't care. The law only cares whether you actually are an employee. And what I mean by that is, how much control does your employer have over the type of work that you do? That's probably the most important factor. And under the Fair Labor Standards Act, which sets the very minimum standards for how employees should be treated, the standard is actually one of economic dependence. Are you economically dependent on your employer? Do they suffer or permit you to work, as what the law says? If you are economically dependent on them, then they should be responsible for making sure you can earn the minimum wage, right? That's the theory behind this standard. So it doesn't matter that you sign a contract saying, I promise I'm not an employee, I'm an independent contractor. It doesn't matter that your employer has, set up some system to make you look more like an independent contractor. It doesn't matter that you're getting a 1099 at the end of the year. No matter what, if you look like an employee and you're being treated like an employee, then you're an employee for purposes of your rights under the laws. That can get complicated in terms of whether you're an employee for the purposes of the Fair Labor Standards Act versus an employee for the purposes of some other law out there. But I think the first hurdle is just letting people know that the fact that their employer doesn't call them an employee doesn't matter. Because people oftentimes will talk to me and think that they don't have an option of pursuing something because they think that they're not an employee in the first place. And so I want to be very clear, that's not something that anyone should be concerned with. The second issue that I think is very, I see occurring all the time is wage theft, pretty straightforward wage theft. People just not being paid for the hours that they work. People being fired and told, we're not going to pay you for the last week. Or the law that governs wage theft in Illinois is called the Illinois Wage Payment and Collection Act. There's another way that this wage theft happens. Rather than just not paying somebody for hours they work, the employer will make deductions from your paycheck. So I'm going to pay you X number, $10 an hour, but at the end of every week, I'm taking this out of your paycheck, I'm taking that out of your paycheck. You broke something and we're going to make you pay it back. We're making you pay for your meals. There's all kinds of scenarios where this happens. And generally, the basic rule is that these deductions are illegal, that deductions from your paycheck are illegal unless they meet certain requirements. And there are plenty of legal ways to deduct things from your wages, but the presumption is that they're illegal under Illinois law unless they meet certain requirements, and unless you've given your permission to have these things taken from your checks. And that's wage theft too, right? So if your employer promises to pay you a certain number of dollars an hour and you're never making it, then that still weighs that whether or not you got paid $6 for that hour when you should have been paid 10. It's also true that if all of these things that the employer does with your paycheck bring you down below the minimum wage, then there's probably a minimum wage law violation. So those two things, I think, are things that people should keep an eye out for in the community. People should know these are not okay. People should know that oftentimes when misclassification is going on, when people are being told they're not employees, when they look like employees, it's being done for a reason. It's being done because the employer is trying to avoid taking responsibility for something that they shouldn't be taking responsibility for. One way that it happens a lot up in Chicago, and I honestly just don't know what happens down here, is through temp staffing agencies. Excuse me. So, if this isn't an issue down here, then we don't need to talk too much about it, but temp staffing agencies are used by employers to insulate themselves from actually being the employer. So I didn't hire you, you're not my employee, you were hired by a temp staffing agency and they just loan you out to me for a little while, so that I'm not responsible for anything that happens to you. And if you're not going to get paid minimum wage, don't look at me. Those are just issues I'd like to highlight as things that come up a lot and that people should be aware of. And then the second thing I want to talk about is what you do if you have these kinds of issues happen to you, or if you see them happening in your community outside of going to the U.S. Department of Labor, which is a great place to go, and they can help you, but they can only help you with certain things, certain laws. And they can't help you under Illinois law. And sometimes Illinois law is better for you, as Todd pointed out. You make $8.25 an hour under Illinois minimum wage versus $7.25 an hour. In some places in Chicago right now, it's up to $10 an hour, and right now, be next to you. So USDL can't help you with that. But the Illinois Department of Labor, Todd was very polite about it. I'm just going to tell you that I have not had good experiences lately with anybody going to the Illinois Department of Labor and getting very much help. Like many parts of Illinois government, it's not functioning terribly well right now. And it's not only slow, but I mean, I've seen instances where people have checks that, like, they're claiming they won their claim. There's checks that are basically waiting for them, and this state's just not paying them out. So it's an option, and it's something that, with enough of a community push to get something done, you might get something done. But I want to talk about some other options for pursuing your rights in Illinois law. One of them is obviously litigation. One of them is what I do. You hire a lawyer, you file a lawsuit. And most employment laws are designed to make lawyers more interested in taking your case given the dollar value. So if I take a case where I'm only going to win a third of whatever you win, but you make $7 an hour and we're asking for your back pay, then a third of your $7 an hour isn't a lot of money for a lawyer to want to take your case on. And maybe we'll never win and I'll get zero. Most employment laws require the other side to pay your fees if you win. And that's not the case. I think people think that's the case for most laws. It's not, but in employment, that is the case. So if I sue your employer for not paying you the minimum wage and I win, not only do they have to pay you your back pay, they have to pay me my fees. And that can be powerful for a number of reasons. One is it might get you an attorney who would be willing to represent you. And two is it makes it expensive for an employer to fight you over something they know they did wrong, right? It's just, a lot of times employment cases are obvious once you get in front of a court. They're either paying you the minimum wage or they're not. And sometimes they're keeping really good records of the fact that they're not. They're either paying you overtime or they're not. And sometimes we know exactly how many hours you work and what you've been paid because there's paycheck stubs. Now that's one way that misclassification is used. They say, well, we didn't keep track of their hours or their pay. We don't give them pay stubs because they're not employees. But even that is something you can combat pretty easily once you get into court. So if you're an employer and you get taken to court and you realize I'm probably going to have to pay something at the end of this case, and when I do, if I settle it right now and pay it out right now, I just pay what I owe my employees. If we fight this for a year, I'm paying what I owe my employees and I'm paying some attorney $300 an hour for the other side. So there are laws that can help you engage in litigation. But I want to put a big caveat on that. From having some recent conversations, I'm not sure how many attorneys there are in the general area that do employment law, wage and hour law like this, how many people there are available who will take on these cases. And even with the prospect of winning your fees at the end of the case, if the case is worth $2,000 worth of wages, it's hard to justify putting all the work into that case. And even if you win, a judge might look at you sideways if you won a case worth $2,000, now you're asking for, $100,000 in fees or something. So it's sometimes hard to find an attorney, especially for just one person who's getting their wages stolen, small amounts of money. And so I want to propose a couple other options. One thing, as this is my dad, by the way, so it's weird. As my dad mentioned at the beginning, I'm on a legal advisory board for Rise Chicago, which is a worker center up in Chicago. And there are a few worker centers up there. As far as I know, there are none down here. But an organization like this, people who get together and care about these kinds of issues, it's something worth thinking about. Worker centers are basically an attempt at saying most of the jobs that we're trying to help people in are not union jobs, right? There's not a union there to help people when they're getting messed with by their employer. There's not that type of stability. There's not that type of organization. And we want to provide alternatives in organizing for people, for workers to get together and help themselves. And that kind of organizing can be a very powerful thing to small business owners who are not treating their workers correctly. They don't like being called out in public in front of the rest of their community for paying their workers $5 an hour. They don't like looking like they're screwing over the people who work for them. And so Arise and other organizations like it, a lot of times long before going to an attorney, and without ever going to an attorney for help, their members will organize themselves and they'll go picket or have a press conference, or sometimes their faith-based organization, they'll have a religious leader meet with the employer or the employer's religious leader to talk about solving the problem in a friendly way before we end up having press conferences and pickets and that kind of thing. And a lot of employers do this out of ignorance. I talk a lot bad about employers up here, and of course there are plenty of good employers and many good small businesses, and sometimes they do this completely out of ignorance for what the law requires of them. They don't realize they're supposed to be paying people in certain ways. They've tried to come up with creative ways of paying their employees that just don't comply with the way the law requires it. They know they couldn't make those deductions, whatever it is. And if somebody comes to them well-meaning and says, we noticed you're doing this, we need you to fix it, they'll fix it rather than getting to a place where you have to embarrass them publicly or file a lawsuit or anything like that. But one worker doing it on their own either might be scared to do it, or it just doesn't come off the same way when one employee coming and saying, I think you don't have the right to do this to me. Employers can be very dismissive of that. They can think that that's just a complaining worker. They could fire that person. And by the way, it's illegal to fire your employees for complaining to you if they do it by themselves. It's illegal to fire your workers for complaining to you if you do it as a group. The National Labor Relations Act says that you can engage in concerted activity. This is the law that allows for unions, right? So if you and your colleague go to your employer and say, we think that you're doing something wrong here, it doesn't even have to be something illegal. We think you need to get air conditioning. It's really hot here. That, they cannot fire you for it. That's illegal. Now, they will fire you for something like that, but there's some protection if they do. So the law itself actually recognizes that there is something different about a group of workers getting together than one person coming up and complaining to the employer. So workers' centers and organizations of workers can be very powerful long before you ever get to a place of having to file a lawsuit. They can also be very helpful if you do have to file a lawsuit. So I've filed a number of lawsuits on behalf of workers who were referred to me by one of these worker centers. And the worker centers stay involved, and they can be very helpful for a lot of reasons. One, a lot of times there are people who speak languages that I don't speak, or who speak them better than I do. And they can help translate for the client. There are all types of small tasks in preparing for filing a lawsuit that an organization that's already been doing all the groundwork beforehand can be helpful for. If an employer doesn't keep good records, they keep the records of hours worked. They help the client get all that together beforehand when they're going and trying to get a friendly solution worked out. And last, they can continue to press the issue publicly, which doesn't help in court. The judge doesn't care whether you're having a press conference or rallying outside the employer's workplace, but the employer still cares. And press pays attention when you go and have a rally and it's no longer just this employer is treating us badly, but it's this employer is treating us badly when you file the class action lawsuit in federal court. You sometimes get more attention in the media when you do that. So those kinds of that type of cooperation between worker centers and lawyers can be very helpful. So I just want to throw out, I've talked for long enough and I'll stop, but I want to throw out those as possibilities and ways to solve these problems. And hopefully in question and answer we can get more.
Thank you. Let me ask you and Todd to stay up here, if that's all right. I'd like to open it up to questions that people might have for either of the speakers, or comments, or other things that you want to share.
There's one more thing I meant to mention, and I just want to mention it really quickly. I talked a little bit about fear and about how people who are undocumented or don't have work authorization might be fearful about coming forward about issues that they have at work. And of course, that's a real concern. There are a couple of things worth mentioning on that. One is, and Todd can correct me if I'm wrong on this, but I think the Department of Labor has a memorandum of understanding with ICE that when the Department of Labor is doing an investigation, ICE isn't going to basically come and screw with their investigation by deporting a bunch of people or doing a raid on the employer. So you should feel free to cooperate with the Department of Labor. And the second is that in really terrible cases where employers basically threaten employees with calling ICE or getting people deported or whatever they might say, if they complain about problems or if they complain about wage theft in particular, there's a possibility for beginning a process to get a U visa. So the Department of Labor and a number of other government agencies have the authority to certify an application for a U visa, which is a visa that immigrants can get if they are basically cooperating with law enforcement as witnesses. So and there are a couple of labor violations that provide the basis for that. So one of them is involuntary servitude. But if you are being forced to work without pay, and when you're going to complain about it, your employer threatens you with immigration proceedings, you might be able to then go to the Department of Labor and get a certification of an application for a U visa, which then potentially gets you a visa to be here with documents for 4 years, and potentially after that, get permanent residency and that kind of thing, legal permanent residency. So there are protections for people who are complaining about violations in the workplace to prevent them from being scared about coming forward because they think something bad is going to happen to them on the back end. The flip side of that, and something that's very real and really unfortunate, is that there are limitations on what you can get if you win a case when you weren't authorized to work. You can recover pay for any work you did when you weren't properly paid, whether or not you were authorized to work. But if you get fired illegally, say for complaining about not getting paid correctly, if you file a lawsuit saying I wasn't paid minimum wage and your employer fires you in retaliation, that's illegal. But if you sue them for that and you win, the Supreme Court has made this terrible decision that you're not entitled to back pay for the period of time after you got fired for work you didn't do, because you never would have been authorized to do that work in the first place is the theory behind it. And the Supreme Court basically said, we think immigration laws are more important than labor laws, so that's the way it's going to work. You can recover something for that period, but not your back pay. You can recover something called liquidated damages in theory. So there's both a good and a bad side of the way the law works with retaliation. But what I would say is going and talking to an attorney or a group that you can trust is one place that you can bring these issues to the forefront without having, or to the government agency, without having to worry that someone is going to come after you because of it. But it doesn't necessarily protect from your employer just retaliating against you and firing you for doing so.
Can you elaborate a little more about how the definition of an employee, so that someone,
Sure.
so that it's easy to understand how you can tell the difference between
Yeah, there's not a bright line where like these people are obviously employees and those people are obviously not. Under the laws that we're talking about today, Fair Labor Standards Act, Illinois Minimum Wage Law, Illinois Wage Payment Collection Act, these laws are designed to protect the most fundamental and basic rights, right? This is the floor. These are not rights protecting your right to unionize, your right to be free from discrimination. This is like, you should be able to not, there shouldn't be child labor, people should make the minimum wage. So the definition of employee is very, very broad. At least it's supposed to be very, very broad. Sometimes courts do crazy things. So the Department of Labor, they're enforcing the Fair Labor Standards Act. All it says is that if you're an employer, if you suffer or permit someone to work for you. Basically, if you're letting them do work for you, then they're your employee. What that means in reality is the test is called the economic realities test or the economic dependence test. You look at a variety of different factors to decide whether or not you're economically dependent on your employer. Do they have control over your hours, over your pay, over what you do when you're at work? Can they tell you to stop doing something, start doing something? Control is probably the most important factor. Are you investing your own resources into this enterprise, or is it all their stuff? Like, do you bring your own supplies and tools and have your own truck, or does your employer provide those things? If they provide those things, then more likely you're an employee. Are you performing something that is integral to their business? So if UPS, if our law firm uses UPS to deliver things, that doesn't make UPS our law firm's employee. UPS is not an integral part of a law firm doing business. But if my business is selling widgets and you make the widgets, then you're probably my employee because that's all we do. We make widgets, you make widgets, so there you go. So there's a number of different factors you can look at, but the basic rule is if I control the way you operate and you look like you're part of my business, and I can basically stop you from earning the minimum wage or make sure you do earn the minimum wage, then I should be your employer. There's obviously some weird gray area between that.
Yeah, I was gonna say that. Yeah.
This classification is a huge thing. We see it all the time. And over the past few years, it's gotten very popular with employers because of the recession. So they're all looking for ways to pay their employees less. And like he was talking, like you mentioned, the 1099 is a very popular way of doing it because when you give an employee 1099, then you don't have to pay them overtime. That's not my employee. That person is their own business, right? So that's what they're basically saying. So when a lot of times we'll encounter this and we have to go through those Supreme Court tests and stuff talking about degree of permanence, how integral is the employee in the business. For example, that none of the tests alone, you don't have to pass all 6 tests and you don't have to fail all 6 tests. It's a very nebulous thing, this proving if an independent contractor can do it. One test could make an employee unsuccessful or unsuccessful. Answer to that could, like he said, the degree of control could wipe out all other 5 tests because that is so significant. But the degree of control is this, if you think of just, you hire a contractor for your bathroom, right? They come in to renovate your bathroom. You say, I want my bathroom renovated, ready, set, go, and they do it. They've got their own set of supervisors, they've got their own trucks, they've got their own materials, and then after the job's done, you say thanks and you pay them. So there's a whole bunch of tests in that little concept. Degree of permanence, when we go out, we've seen contracts we've seen employee handbooks that look very, very much like a contract. But when you really sit down and look at it, it's not a contract, it's just a handbook, right? Degree of permanence, is there a start and an end to it? Is there an opportunity for another person to come in and outbid this person for the work that they're doing? Has the employer contracted out their primary mission. You know, if your primary mission is creating widgets, are you contracting people to create widgets, or did you contract someone to fix your air conditioner so you can make widgets? So that's the kind of the concept, and that's, we have at Department of Labor have to wade through a lot of that stuff to create a case file and try to get an administrative resolution, and if we don't, then I
There are even situations now where people will make their employees create companies, like paper companies, to make it look more like they're independent contractors. So we're settling a case right now where all these guys are driving AAA trucks to jump your battery and change your tires. And the company they work for, Club Assist, just one day said, we don't have drivers anymore, none of you are our employees. You all have to go start your own LLCs if you want to come back and work for us. And so the next day, everyone has their own LLC, but they're doing exactly the same job with a 60-page contract that tells them the fine details of what they're supposed to do. That person's still an employee as far as I'm concerned, and I think as far as the boss is concerned, and we settled the case for a lot of money, so I think that they ended up deciding that was right. I think so.
Yeah, I was wondering about how affordable are the alternatives you were talking about.
Sure.
So it is, I think we all know that especially undocumented immigrants cannot afford a private attorney, so they have to go to other, look for other attorneys. And I know you can agree upon contingency fees for a private attorney, but then is it really affordable for an attorney, and how compared to the centers, the working centers?
Sure.
Is that affordable?
So worker centers, I think, mostly are free. I mean, they operate on they're nonprofit organizations, and there's a fair amount of foundation funding for them, although I think that's dried up slightly recently. So the idea is that workers shouldn't have to pay. A lot of them require workers that want help from the organization to become members and to give up their time and organize with them. But that's about it. The question about how contingency arrangements work. So I can only speak for the way our firm does things, but I think it's a relatively typical way to do things. There are cases I'm going to turn down because the economics of it just don't make sense, or because I don't think it's a good case. And so if I'm taking on a case without someone paying me up front, I want to know that there's a good chance I'm going to be able to win. If I think it's a good case, and I think that I have time and all this, what our sort of typical arrangement is you pay nothing. If we win, we will recover a third of what you win, but we'll count any recovery of our fees dollar for dollar against that third. So if you won $30,000, $10,000 of it would come to me. But if I ended up doing $50,000 worth of work on the case and the court awarded me $50,000 from the other side, I'm not going to take any of that $10,000 because the $50,000 is way larger than the 10. If I only got $5,000 of my fees back from the court, I would take $5,000 from your share in order to make up 1/3, but I would never take more than a third, in other words. I think that's a fairly typical arrangement. And so, yeah, I think it's affordable if because 2/3 of what you're going to win is better than nothing. But it's not always worth it still. And what I mean is, first of all, it can be hard. It's hard for attorneys to take on all these cases sometimes, so sometimes you can't find the attorney. It's not worth it for them. Sometimes it's not worth it for the client. I mean, it's not fun to be a plaintiff in a lawsuit, and it can be really difficult and trying, and you may be deposed, and this is something you have to stick with for a very long period of time. And so I've never been a plaintiff in a lawsuit. I only represent people who file lawsuits. I've never done it myself. I don't know that I necessarily want to. So for a few $100 or $1,000 worth of wages, unfortunately, sometimes it's not worth it to get yourself into that mess. But it's less about paying the attorney and more about, the headache. The one caveat to all of this, is that we will, in cases that are worth, if you come to me and you're a doctor and you're looking to file a lawsuit for your back pay and you were making $300 grand a year, far more than I make in a year, then I might ask you to pay me something up front. But if you're a minimum wage worker, then I know you're not going to be able to afford me to, pay me at my hourly rate. So that's just not the way we would do it. That doesn't mean it's easy to find an attorney. Of course, pot is free, and I'll
We're free, so in those cases that don't seem to have enough of an economic outcome, we're happy to do that. That's what we get paid to do. So give us a call, and you know, we also get, ironically, we also get attorneys calling our line a lot, asking us questions about how to give an answer to a specific client. We'll get salary questions, and we'll get questions from attorneys about, we're going to have a plant shut down for 2 weeks, and how does that affect the non-exempt worker and salary employees? Can we still maintain an exemption for them, and all those kinds of issues? So give us a call. We're here, and that's our mission statement, is to assist with low-wage workers. So if you're not economically stable, give us a call. We'll do what we can to help.
Okay, question here, then a question there.
Yeah, so I think both of you talked about how, like, fear of deportation and other, like, issues might deter the undocumented labor force from working through legal channels. Like, do you find from your experience that payroll taxes might also deter people from working through legal channels, if it just doesn't make financial sense for them to be working as a legal employer or worker?
I have not experienced that. I have not experienced any kind of situation with payroll taxes. Most of the time, I encounter situations where folks are generally happy to see us. There are times when we walk into a surprise situation, and we do have badges, and sometimes if you show the badge at the wrong time, everybody's gone. There goes all your witnesses. There goes all your statements, as everybody runs as they make your immigration. So, but I have not had any obstacles that are created by payroll taxes.
Yeah, my experience is similar. I think most workers, for the opportunity to work, are willing to pay taxes, even if they're undocumented. They know they're not necessarily getting credit for the fact that they're paying taxes. I've represented people in very sort of casual working arrangements, you know, doing delivery for restaurants and things like that, where they're getting paid all cash and nobody's paying any taxes. And I think some part of them probably likes the fact that they don't have to do that, but they also would like to be getting paid correctly in the minimum wage, and they take that over not having to pay taxes every day. So.
Question. So I worked for a labor union from campus services for employees, and a lot of these resident employees tend to be international. So I wanted to ask for the international students who are employees at the university, and most of them will be like between the 25% and 67% of like foreign employees. But they have access to like a visa, and I know a lot of them sometimes there's a lot of fear on like if I bring this to my employer, if then they don't hire me, then I don't have a visa, or if the fact that visa status. Like,
Yeah, U visas are available to, I mean, yes, if you are an immigrant and you are basically the victim of certain crimes, and you are a potential witness for a law enforcement agency, they can give you a certification to get your U visa application. And that's a very good thing, but it is not, it's hard to check all those boxes. It doesn't happen all that often. And even when you do, it's a very long process. So we did help some workers get U visa certifications from the U.S. Department of Labor 2 years ago, and I think they're still on the pathway to maybe getting their U visa. So it's not like, you know, it happens like that. But basically, what has to happen is that you're the victim of certain crimes. Some of them are labor-related crimes, and that you are willing to be a witness for the U.S. Department of Labor and it comes up far more frequently in a non-labor situation. Like if you are a victim of domestic violence and you report that to the police, and the police can help you get a visa, or the state's attorney can help you get a visa. But it is a potential possibility in the labor context. I would hope that there's nobody in the Graduate Student Employees Union at the U of I who's a victim of a labor crime. You know, I'm sure there's probably some civil labor law violations, but I hope not involuntary servitude. So it usually comes up in the worst of scenarios. So theoretically, yes, but I'm guessing there's probably isn't going to be something available to too many graduate students.
you. So does your office regularly get requests for U visas? Is that something that they don't when you're dealing with immigrant workers?
U visas don't even come near my office. I work at the district office level, which is one echelon below the lowest echelon where a U visa would come from. That would come from the regional office in Chicago. I work out of the district office in St. Louis is the district office, and I have an area office. And so if a U visa situation would occur, that would come at a much higher staff level, and that's at the regional level. That's where it would start. So.
And so, but let's say you were dealing with an immigrant who felt like they wanted to get one, you were working on their case, and they asked that. You basically kick it out to someone at I don't know and say, I think this is a good situation for that, and they requested that. Is it up to them to request it, or is it sort of within your purview to recommend it?
Well, I mean, I would recommend it. Of course, they would come to me and want to know all the circumstances. So if I walked into a Chinese restaurant where I thought there was human trafficking going on, then I might get asked for all my interviews and all my material that showed that there's a justification for a U visa. But that person, of course, has to want to have a U visa because ultimately the purpose is to testify. So they have to want it first. If they do, then yeah, certainly I can get this going with the staff element that's part of it. But you know, I've got to have something in here that says my employer's holding my visa or something, my passport or something, restricting my ability to leave.
Yeah. That's the types of situations, right? It's human trafficking, it's taking identification, refusing to pay people and saying, report me though. That's why I doubt it's something that any union member is dealing with. And also to be clear, what the DOL would give you is a certification, but then you still have to go through this whole process to get your visa. It's not, the DOL doesn't give you a visa, they sign off on your visa application.
And it's generally in different agencies in which that is obligated. It might be Department of Labor, Office of Inspector General, it might be FBI. FBI is human trafficking. If we walk into it, then we know that we get as much documentation as we can to justify a further on action. But does that answer?
Yeah. Other questions that you have? Tom?
Do these same general parameters apply to work-related injuries in terms of deciding which employee includes it, or is that a whole different?
Yeah, well, for workers' compensation purposes, the test in Illinois for whether you're an employee is also a very broad one. I think it's sometimes called the ABC test, and I think there's 3 factors ABC. Theoretically, it's kind of more on the employer to prove that you're not their employee, so that helps you. Number 1 is, do they have control over you both as a matter of fact or of contract? So if they have a contract that says they can do stuff, but they've never actually controlled you, then they're your employer, and if they actually control you, then they're your employer, whether or not they have a contract. The second one is, do you work in their place of business versus, you're out in the field somewhere? And that can be a gray area if you work in a job where the whole business is out in the streets, like AAA drivers, for instance. But, are you actually in their place of business? If so, you're their employee. And the third is, do you have an independent occupation or profession? So, are you the attorney for some company, and so you have your own, attorney's not a very good example, but you get it right, you have your own business that you run separately from. For injury purposes, it should not be too difficult to prove that you're an employee if you look anything like an employee for purposes of getting workers' compensation.
Other questions?
When an undocumented employee files a lawsuit against his employer, does it protect him from removal procedures?
No, it does not. It should never become an issue in the lawsuit whether or not that person is undocumented. It should not be relevant to any question being asked except for maybe what damages they're entitled to if they got fired illegally, like I was talking about before. So I've never had a situation in a federal lawsuit where the fact that I had clients who were undocumented ever became public in any way, shape, or form. It could theoretically, though, and nothing would stop removal proceedings in that situation. I couldn't do anything to stop it. It's a little different if you're working with the Department of Labor. Like I said, I think the Department of Labor has an agreement with ICE that they're not going to interfere with one another's investigations. So once the Department of Labor is working on it, ICE isn't going to come in and start raiding the employer.
And so does that make, so if someone has a complaint and maybe you're possibly solving it, but maybe not, is it good practice to file a complaint with you so then you're protected, if you're undocumented, to have some protection? Does the very fact they file a complaint with you provide that protection, or is there some threshold that someone has to make or reach for that to kick in?
There is no filing a complaint with us is completely confidential, first and foremost. We'll need to know all your information because we will need to communicate with you. You are basically for us the star witness for as moving forward. You'll be asked if you want, if we can use your name with the employer, which even if you give us permission, we don't do it unless we absolutely have to. So most of the time we get no written question. So it's a confidential situation. In the Fair Labor Standards Act, there is a stipulation that says that you cannot be retaliated against for filing a complaint or for cooperating with wage and hour investigation. That being said, guys, it's completely hard to prove that you were terminated because of something. Basically, the employer's going to have to say it out loud in front of 2 witnesses that I'm firing you because you fired out. It's really hard. So, you walk in 2 minutes late to work one day, you're fired. So, as you file a complaint, we're going to keep you, we're going to do everything we can do to protect you from the employer knowing who you are. And if you all ever want to file a complaint with us, don't tell your fellow employees you're filing a complaint with us either, because they'll chatter and then the cat's out of the bag. So, okay?
Yeah, I have another question. There was a case here where some people were working for a company, a cleaning company, and after several weeks of work, they were terminated and told they weren't going to get paid. Would that be a case that would fall under your jurisdiction?
It could. Again, the very first thing that we have to have under the Fair Labor Standards Act is coverage. So the employer must have grossed at least $500,000 a year, or the employee must be engaged in interstate commerce. Now, there's a stipulation of interstate commerce which seems to apply to janitorial employees pretty heavily, which is called crate. If you are a crate employee closely related and directly essential to production of goods for interstate commerce, then you are covered. So if you are a janitor who cleans a building in a doctor's office, that service now, by the way, this is new, service is now considered a production of goods. So if you are cleaning a building where this kind of occurrence is happening, then even as a janitor, you are directly essential to the production of goods for interstate commerce. So the answer to your question is very likely we can help, but again, there may be an economic reality here as well with our agency. So if you have just a couple of weeks and just a couple of employees, we do the investigation and we fine for these employees, and the employer says, no, I'm not paying, then we have to submit the case to the regional solicitor's office. Now, this is where, you transition from book to reality, which is the regional solicitor's office is going to look at the case and go, all right, we got this closely related and directly essential stuff in here, and it's a little bit weak, we got interstate, maybe if we had enterprise coverage with $500,000, we could file a suit, but ultimately what might have been happening is that employee might get a letter from our agency, unfortunately, that says, we found this in violation, you have a private right to action to sue, you can't pursue it.
But you're more likely to get an attorney to take your case if you have something from the Department of Labor saying that they found a violation. If that's a signal to someone like me, this is probably the case.
Yeah, and we will letter everybody. If we go to an establishment, there's 50 employees, the employer says no and the solicitor's office decides not to take it, we'll letter all 15 employees. Everybody's going to write a letter that says there's a violation here. We found it, you all should go sue. So, question back.
Hi, I'm Brian Melliner. I'm sorry, I can't make the whole meeting. I had to come late and leave early, but I have a more general question about what kind of pressure is being brought upon the University of Illinois. As I understand, these worker intimidation cases are happening at some of these large housing developments on University Avenue. This is the university outsourcing its housing options to these big developers, and the big developers in which are exploiting the local immigrant population. So what pressure is being brought to bear, if any, on the University of Illinois for its complicity in this kind of intimidation?
I wish I could tell you, but it's not, you know.
Maybe this is a question for the larger.
Yeah.
I don't have, as far as the Department of Labor goes, I don't have an answer for that either. There's nothing specific to that. The term used, exploitation, is a bit nebulous. So, you know, if we were talking on the phone, I'd ask you to define that and tell me how are they getting paid? Is it about hours of work? Is it overtime? What's the situation? You know, exploitation can mean a lot to a lot of different people. It could be stewards or, you know. So, but there is, as far as I know, there's nothing specifically targeted on that situation. But if there is something that falls into our lane, there is a card that tells you how to file a complaint.
Yeah, I would, my answer would be what I was talking about early on, maybe before you were here, which is just that I think a lot of problems are better solved through either organizing on its own or organizing combined with litigation. And this sounds like one of those problems because the University of Illinois is, based on what I'm hearing of the explanation of the situation, I know very little, probably not the employer. And so pursuing them for liability in a lawsuit is probably going to be very difficult. But making people generally aware of the fact that the people who they are outsourcing to are doing these kinds of things may end up putting pressure on them to do the right thing with how they interact with the communities.
Other questions? Well, I want to thank both of the speakers for coming, for all of you coming out tonight. I know there is interest. There have been a couple of cases, CU Immigration Forum and La Linea have got calls on. And so I know there's a small group of people who are interested in seeing what can be done and how we might be able to either pursue things legally